I'm not really sure how helpful this evidence actually is when it's you know, on photo. It's not putting in any new photos. It's just trying to say, and certainly in circumstances where there's not going to be any cross-examination, so trying to decide whether photos are manipulated or not. I mean, it's a very serious thing to find without Mr. Preslett being cross-examined, without hearing from Mr. Keane. I'm just not sure it's a finding I'd be terribly enthusiastic about trying to make on the papers in the absence of cross-examination.
We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
If you like it 400 times and it shows a greater degree of damage, then my point is, when you look at this in close-up, you see there's a lot more detail, a lot more damage than was in the original photo. Seems to be the point you're making.
Please be seated. This High Court is now open for the matter between Joden Finance Limited and the Auckland District Court and the matter.
May it please the court be for the applicant. I have a memorandum that I've handed up to the court. Take more reading on it.
Okay.
Please run a council's name is Mrs. Koyaba. I appear for the second respondent, Mrs. Preslett.
Thank you, Mrs. Koyaba. Okay, Mr. Beard.
Your Honour, the second respondent has an interlocutory application. Will we deal with that first, or?
I'm in your hands. Is this to do with the evidence?
Yes.
Right, okay.
Or should we go straight to the...
No, happy to deal with that. That's first. Okay, so that's, well, it's essentially you're wanting to admit new evidence on appeal, is that right?
That's correct.
Or not on appeal,
not
under review.
Under review. Our position is that the decision maker was materially influenced by incorrect information.
Right, okay, but it's the, is it the, so it's the second respondent's application to strike out your affidavit, is it?
That's correct. It's to strike out Mr. King's affidavit, and Mr. King is actually at the back of the court today.
Right. Okay, well then I better hear from Mrs. Boyard on that first then.
That's fine, please.
Thank you, Madam. Now, did the court receive the supplementary submission regarding the strikeout? They were filed at the same time as the synopsis of submissions.
So submissions of second respondent in support of interlocutory application for order striking out.
Yes, ma'am. To be quite brief, but I will just address those now. The legal burden of proof on the applicant in a judicial review is to prove both the facts giving rise to the grounds of review and the justification for the court to exercise its discretion. The court retains an inherent jurisdiction to strike out irrelevant or inadmissible content in excellent evidence. Your Honour, Mr. Beard, my friend today, has framed the matter as perhaps an application to admit Mr. King's evidence.
No, I think I asked that. I think it's your application to strike out.
It is, ma'am. So Mr. King's affidavit has been filed. And it is our application to strike out that evidence. Affidavit evidence would result in, if affidavit evidence would result in potential for a substantial loss of focus and considerable expansion of the case outside its proper limits, it should be excluded. Now, Before we can consider the specific evidence, we must touch on the grounds of review and judicial review in this case, to see whether the affidavit can be said to be relevant. So there will be some crossover with my submissions later, but I will just touch on the three grounds of review that the applicant has filed the judicial review on the basis of. The first is error of law, and that the interpretation in the District Court of Section 21C of the Consumer Guarantees Act was an error of law. The second is an error of fact, and that the applicant asserts the District Court's finding that the damage to the vehicle in question was minor, and this also incorporates the applicant's assertion that the District Court failed to consider the new evidence, which has been admitted for the purposes of judicial review today, which is alleged to show more substantial damage. And the last ground is unreasonableness. In the course of the District Court appeal, the applicant made an application to adduce further evidence. This was photographs of the vehicle taken by Mr. Murphy, the director of the Joden Finance. This application was opposed in the District Court, and Judge Harrison dismissed the application, giving oral reasons on the 13th of February 2020. The applicant has applied to adduce the same evidence for the purposes of judicial review, and His Honour Justice Palmer has admitted that evidence after an interlocutory hearing in this court. And I give that background as way of context for Mr. Keen's evidence, because Mr. Keen's affidavit has been filed. He purports to be an expert in detecting digital modifications to images and video production. Now, putting aside the question of whether Mr. Keen ought to qualify as an expert or not, the thrust of Mr. Keen's evidence appears to be his opinion as to whether the original photographs produced in the tribunal were modified or altered in any way when comparing them to the new evidence that has been admitted for this purpose in judicial review today. It is Council's submission that this opinion evidence is not relevant when considering the matters before this court with reference to the grounds for judicial review. This was not evidence before the District Court. No application has been made to reduce the evidence for this purpose. But most importantly, the evidence, the opinion, the comment, is simply not relevant to the grounds for judicial review today. Council submits that Mr. King's evidence cannot be relevant to any analysis regarding an error of law. In relation to the ground for error of fact, this evidence was not before the District Court or even in existence at that time, and it cannot be relevant for the assessment of judicial review of error of fact. Mr. Murphy's new photographs and new evidence in themselves are, and Council's submission, only relevant to the extent this evidence relates to the assessment of whether the decision maker fails to take into account relevant considerations. Indeed, the Court, Justice Palmer, has directed the evidence should be admitted for that purpose, namely to assist in assessing the decision of Judge Harrison not to admit the evidence in the District Court. Any purported opinion about the nature of the original photographs produced by Mr. Purcell, or comparison with the now admitted new evidence, which was not before Judge Harrison in the District Court, simply cannot be relevant to the judicial review before this court. Such evidence would expand the case beyond its proper limits, and it is for these reasons that Council submits Mr. King's affidavit should be struck out and not read for this review.
thank you for that. Mr. Beard.
As the court pleases. Your Honour, if I may, the crux of my learned friend's application is in paragraph 12 of the memorandum dated 23rd of November 2020, where it alleges that Mr. Keen's evidence is irrelevant when considering the matters before the Court of Judicial.
So, sorry, what are you referring to?
The memorandum dated 23rd of November from Ms. Briala, and that is undercover.
Okay.
Yep.
Okay, so in paragraph...
Paragraph 12. It alleges that Mr. Keen's evidence is irrelevant when considering the matters before the Court of Judicial Review with reference to the statement of claim. However, at paragraph 13 of the actual strikeout application, the second respondent pleads that the fresh evidence is only relevant to whether the decision maker failed to take into account relevant considerations. That is incorrect. The applicant has also submitted that the decision maker was materially influenced by the wrong information. Mr. Keen's evidence correlates with the vehicle being driven at such great force towards a concrete curb as to blow the tyre and damage the wheel and body. At CV 459, the common bundle, Exhibit P.
No, understand that. So we're looking at
CV 459, and that's the affidavit of Keen, and I'm taking you to an exhibit. Yes. There's clearly a piece damage to the bumper and a piece of metal sticking out of the vehicle. And there's other photographs in.
So what do you say that photo shows?
It shows a piece of chrome. It shows damage to the front bumper and a piece of chrome sticking out.
Is there a photo of this from further back?
Yes, that's also in Mr. Murphy's, I believe. But then when we go to Exhibit N, then it also shows more extensive damage to the tyres.
So whereabouts?
That's the page 457.
Right.
So moving on, paragraph 9 of the applicant's statement of claim sets out the applicant further contends that the damage was not at any rate minor, and the damage caused by the second respondent's parking accident was careless or reckless, such that it could not be considered damage attributed to ordinary wear and tear.
So just pause. The key thrust of Mr. King's evidence, as I understand it, is he's not putting in new photos. He's trying the key thrust, or the key point of his evidence is to try and say that the original photos were manipulated.
Precisely, Your Honour.
Right, and how's that going to be substantially helpful?
It reinforces the theory of Mr. Murphy's case, which throughout the disputes tribunal transcript, Mr. Murphy has contested the evidence.
So has Mr. King put in any new photos of his own, or he's just analysing Mr. Murphy's photos and the other photos?
He analysed and put those together in his exhibits.
How does, I'm just trying to figure out, how does that assist? I mean, as counsel, presumably you can point to the original photos, you can point to the new photos and say, the original photos show this, the new photos show this, there's clearly more damage in the new photos than the original photos. How's it substantially helpful to know whether those photos, and in the absence of any cross-examination of anybody, for me to try and determine whether photos have been manipulated or not. I mean, if there are new photos, which have been admitted, as I understand, showing significantly more damage, then presumably you go to the new photos and say, well, no, here's photos showing that the damage was greater than the district court was led to believe. Whether or not the original photos were manipulated. I'm trying to just figure out why it's significant whether or not the original photos are manipulated.
Right. It's significant because that's all the information that the MBDT had at the time of the hearing on the 18th of July. Mr. Murphy never had access.
But whether they were manipulated or whether they just, whether they were not very clear, was the light or whatever, if you've got photos showing more damage, isn't that the key thing? I mean,
Mr. Murphy's, the ones that Mr. Murphy took with Mr.
And they're in.
Yes.
They're in, and they're I think just as far as they've done, haven't they? I'm just struggling to see why. And I'm not sure that I can make a finding on manipulation without. I think Mr. King's expertise on photo manipulation is questionable on the affidavit. B, he hasn't qualified himself as an expert in terms of the High Court rules to give opinion evidence. And C, I'm not really sure how helpful this evidence actually is when it's on photo. It's not putting in any new photos. It's just trying to say, and certainly in circumstances where there's not going to be any cross-examination, so trying to decide whether photos are manipulated or not. I mean, it's a very serious thing to find without Mr. Preslett being cross-examined, without hearing from Mr. King. I'm just not sure it's a finding I'd be terribly enthusiastic about trying to make on the papers in the absence of cross-examination. And I'm just not sure that it's going to be, determinative or substantially helpful. So that's what I'm struggling with.
Your Honour, there was one issue raised in Mr. Preslett's affidavit about the connection with the photographs and whether these were in fact the original photographs from the NBDT that Mr. King analysed. And I would say, insofar as his evidence is opinion, running it through a Microsoft Windows program, which is a fairly common program when you're reading the affidavit, that would be a subjective process using software package rather than opinion.
Well, he's got no direct factual. He's not giving evidence of fact. He wasn't in the car when it hit the curb or anything.
No.
I mean, he's giving expert opinion evidence on whether these photos have been analysed or not. I mean, it's not factual evidence. I mean, it can only qualify for admission as expert opinion evidence. I mean, the opinion is whether these photographs have been manipulated or not. And to give opinion evidence, he's got to be qualified as an expert in this area. I mean, why don't you, just so I can help me decide whether it's substantially helpful or not, take me to a couple of the key examples where he says photos have been manipulated, and perhaps show me why this evidence is likely to be substantially helpful to me.
Okay, so Mr. King has used a program called Windows Picture Viewer and a zoom function to inspect the images and enlarge them 400%. He then took originals from and matched them to the sections of new images. So if we go to D and G exhibits on view image from D, and that's with the section enlarged on G.
Okay, so what I'd like to see is like an original image and a new image, so to highlight the point that the original one's been manipulated.
So we have Exhibit B goes with Exhibit I.
Okay, so is B an original?
B was a new image of the front left tyre.
So, yeah, I'd just like to see one that was before the tribunal that Mr. Preslip submitted, and then Mr. Keen's evidence as to why I should infer or find that photo was manipulated.
Ah, right. Your Honour, Exhibits H and I. Now, we do have further documentation, but Mr. Keen can't swear that in today, showing the email trail for these photographs from the Department of Justice, Lucianne Keen, from the MVDT file.
No, I mean, we're obviously limited to whatever's in his affidavit, so you've got to make submissions based on that.
So H and I, but these are old photos, I believe.
So H says new
Well,
image.
this is
Sorry, so H is a new image.
from Mr. Murphy's.
Yeah, so what I want, because the allegation is that the photos that Mr. Preslip submitted to the tribunal were manipulated to make them not as serious. So what I'm looking for is for you to take me to one of Mr. Preslip's photos he submitted to the tribunal, and then Mr. Keen's enhanced photo or new image to compare, to show that the original one must have been manipulated.
May I just please confirm?
The ones I'm calling new image are the new ones I got.
That's the original one?
The ones called new image are the ones from the tribunal,
Right.
which I compared to the originals that John took.
Right, it's been clarified. The ones called new image are in fact the ones taken from the trial. And if we go to page 452,
Right.
that item that says new image 404, that is the picture that was at the MVDT hearing. And these other arrows going out are the analysis that Mr. King has performed using software, readily available software.
Right. Because those, I mean, we look at, can we go back in the common bundle somewhere and just find some of, can you take me where the photos are that were before the tribunal? So not the new photos, the photos that were in evidence before the tribunal.
Right. They are not in the common bundle. 19. Right.
The tab 19, the ones in there are the ones that were before the tribunal?
Yes. And here we have 160. We'll go with yes, image 160 would go with new image on page 452.
Okay, so there on 160 we can see that scraping and that bit of the tire there. Okay, and then if I go to 452, what is that?
Okay.
Trying to show?
On 452, then there's various arrows going to sections of that wheel that have been enlarged 400 times using the program Mr. King refers to, and showing that the damage is relatively more significant than it appears on Mr. Preslip's photograph filed in the MVDT. Same evidence.
Right, so he's enlarged it 400 times.
Exactly.
Well, if it's been enlarged, I mean, how does that necessarily indicate? I mean, without saying it's been manipulated, I would have thought you'd say, well, we've enlarged them 400 times, and now you can see the damage more clearly, and it's more significant than it looks like in that original photo. I can understand that. I'm just not quite sure. I'm not sure why it matters whether it's manipulated or not. I mean, if you enlarge it 400 times and it shows a greater degree of damage, then what your point is, when you look at this in close-up, you see there's a lot more detail, a lot more damage than was in the original photo, seems to be the point you're making.
Yes, Your Honour, and that page 160 picture of the tyre is a very big picture, very clear, and you look at these smaller ones, how visible this damage is on 452 and the preceding pages.
So where's the original one again?
The original one is at 160,
Okay.
and it's a big full-page photo.
So I'm just having a wee look here. So there are three lots of photos submitted post hearing. Just trying to look. So the first lot is the first lot, and then so there's another photo submitted for tribunal at 165. Doesn't that look the same wheel there?
Yes.
And then 166, I assume that's the same wheel.
But also, Your Honour, if you look at 164, you can't see a piece of chrome sticking out of the vehicle where the bumper is. Interestingly, as you can see at 451. And those
I
Mr.
can't
Murphy
see anything much in 164. It looks very dark to me with lots of reflections.
But if Mr. Murphy took photos and Mr. King has exhibited that at 451, and if you look at that angle of the vehicle, at 451 there's this piece of chrome sticking out underneath the headlight where the bumper flips on.
Well, does that suggest the damage could have been done later?
Well, these
I mean,
photos
there's
of
obviously
Mr.
various explanations for this, and in the absence of
photos-
cross-examination, I don't know what inferences.
Well, photos from Mr. Murphy, he wasn't allowed to inspect the vehicle or take photographs until the 18th of October, well after the hearing. So he had no opportunity to identify the wrong information or be precise about it.
I can't even really see Patty's programs together. Let's have a look at these
Oh, at
photos.
451 on Exhibit H.
I mean, I just couldn't say what the significance of that. It looks there like something that just could be clicked back in. It's just, without expert evidence, I just don't even know what that photo is how significant that is, but I should put a tag on it. But I'm just going back to look at these tyres. So are these all, that's the left, they're all the left rear, on 12 and 166 ones. Are they all photos of the same tyre?
The front left, yes.
Oh, so we've got, so the next two are actually
So if you look
back
at-
left, aren't they?
Sorry, Nora.
So I'm looking at 166, 167, they're actually the back left tyre, those ones.
Right.
So what, it's the front left I need to be looking at, isn't it?
And 164, if you follow that line underneath the headlight on 164, and then you look at the one at 451, that's where that piece of metal in the bumper.
So your fundamental point, as I understand it, is that, because the damage you're saying is the front left tyre, is that right?
Yes, the one.
Is that the original photos don't show the damage to the front left don't accurately show the damage to the front left tyre.
Exactly.
Photos need supply to the
The,
project.
the photos Mr. President supplied don't show it.
Yeah, that's fine.
All the body damage.
And where's Mr. Murphy's photos and what about, I see there's reference to photos that Mr. Murphy took of the car when it was in his shop originally. Have they ever been produced?
No, Your Honour, I don't believe that any photos exist. In
Apparently
that,
he sent an email to the tribunal saying he had some, but I don't know if they were ever produced. Perhaps they haven't been. But I saw reference somewhere in the papers. So where's Mr. Murphy's photos that he took? The
They
new
will
ones that
be-
are happy admitted? They're at.
they
are they
will be
ones-
his application to reduce bridge evidence, I imagine.
I think they're. There's this, a colour set from 58 on, I think, aren't they?
Here we go, Mr. Murphy's ones, and they're showing the damage to lights as well. And also,
Okay. So anything else you want to say about the evidence?
yes. I would submit that error of fact has always been an issue in this case. And
So this is in terms of the application to strike out Mr. King's affidavit?
yes,
So
yes.
you're saying it's relevant?
It is relevant, and it's in the pleadings. I would also say it's in the transcript at CB 41, line 19. Mr. Murphy categorically states it's been damaged since he purchased it. Mr. Murphy has always raised that as an issue. Mr. Presslip at CB 46, 47, and 48. Yes, I understand what you mean now. Like sometime I park too close, so there's a car, hit low curb, not much there is. It implies it's more than one this has occurred. And then at Common Bundle 345, tab 26, minute of Walker J, in this High Court, the applicant confirms that the applicant pleads error of law or fact. I would say that the applicant has always contested the extent of damage to the vehicle, and the tribunal was influenced by materially wrong information and the wrong facts. The second respondent refused the applicant or his expert to allow an inspection of the vehicle prior to the NBD hearing. At CB 101, paragraph 5, Mr. Presslip proposes the hearing took place on 18th of July 2018. Then at CB 104, at paragraph 15, Mr. Presslip deposes that in early October his former lawyer consented to Mr. Murphy taking photographs.